Hi, guys. My name is Natalia Porsche. I think it's working now. And I am an attorney who is based in Biloxi, Mississippi. And I decided to create this video about Mississippi DUI laws. I think it's going to be very helpful for some people, although it was very helpful for me personally to go over DUI laws in Mississippi and over every law that is connected to DUI's law, specifically Fourth Amendment of the United States Constitution. So why I have a passion for DUI laws is very, very interesting how DUI laws override Fourth Amendment of the United States Constitution, which states that every person who is in the territory of the United States is free from unreasonable search and seizures, right? So, which means arrests. So, anybody here who is in the United States is free from unreasonable searches and arrests. So that's why I find DUI laws very interesting because basically it overrides Fourth Amendment of the United States. Okay, and we see how it happens. So again, my name is Natalia Porsche, and I'm an attorney in Biloxi, Mississippi. I practice DUI laws, criminal defense, immigration, and family law. So let's go over. I created here a little slide for us. Again, guys, I'm going to go forward with a disclaimer. So all information on this channel or during this video is for informational purposes only. It's not supposed to be treated as attorney-client communication or attorney's advice. So therefore, if you post any comments here, then I will not be answering. And the reason why, because I will not be providing any attorney's advices here as far as your specific situation. I would recommend you to contact an experienced DUI attorney. Make sure that DUI attorney knows what he does or she does, that DUI attorney took some training, DUI courses, and anything like this, which can be very, very helpful. Therefore, this is a disclaimer. So let's start. We have a little outline that we're going to go forward with. Let me just, add this to stream. Give me 1 second. Okay, I think this is good now. Okay, and guys, again, this will be available on our website. It's www.okunievskylawfirm.com. My name is Natalia Porsche again, and I'm managing attorney at Okunievsky Law Firm PLLC here in Biloxi, Mississippi. Okay, let's start with our outline. So here you can see this is outline created by me. Let's go forward to our next slide. Okay, so again, this is a disclaimer. Okay, so let's go over quick overview of phases of DUI procedure, right? So what the police officer must do in order to bring this conviction in court and essentially to convict you of DUI, right? So there are several technicalities, right? And they're very, very difficult. Some of you might think that, oh, it's very easy to get DUI conviction. It is, but if you follow the rules, right? Not everybody follows the rules. We're all humans. We make mistakes. Therefore, that's why you have defense attorneys. You have defense attorneys so that we can pinpoint, we can go to the law and we can tell how this officer was not correct with correcting certain information or doing a DUI breathalyzer test, right? There are certain procedures that they have to follow. And sometimes, a lot of times, actually, based on what I know, cases that people that I represented, cases that I won, I can tell you that people make mistakes, officers make a lot of mistakes. And the worst thing is they don't like when they start getting questions, from a defense lawyer, and defense lawyer begins to dig into the details, begins dig into the procedural steps, analysis, why this person was pulled over, what is the reason, why his or her Fourth Amendment was violated. So let's go over again. first, any DUI traffic stops begins with the first step, right? So that happens when the officer observes the person driving, right? So we have here, as you can see, I created the outline. So the first step is the police stop. Okay, so this is how DUI begins. This is how DUI investigation begins. It begins from him, the police officer, or her watching you driving, right? So okay, so here's the rule: police officer cannot pull you over unless there is a reasonable suspicion that the driver is engaging in a criminal act, which is DUI, right? So what happens at this point when an officer watching you driving, the officer decide whether he or she has a reasonable suspicion to pull you over, whether he or she would like to follow you first and find out if they can collect any evidence. So this is the stage when they begin collecting an evidence against you to build their case and take you to court and get you convicted. So it's their job to build their case. So this is the first step: reasonable suspicion. Okay, so at this point, a police officer opens his report and begins gathering evidence to arrest you for DUI. At this point, an officer is already thinking how he will be testifying in court against you. So this is when he begins following you, right? Watching your steps, watching what you're doing, how you're driving. And we're going to go further into the details about how they observe it, what kind of cues, and I'm going to explain to you what cues mean. They need to gather in order to get this reasonable suspicion. Also, guys, there is another thing, which is a traffic violation. So we have reasonable suspicion and we have a traffic violation. Okay, two things for which the officer can pull you over, can stop your vehicle and keep gathering and gathering and gathering more evidence against you by building this case, right? So that he or she can take it to court. Okay, so traffic violation will be another reasonable suspicion, which will be escalated, that the officer will have to escalate that to a probable cause. Okay, so reasonable suspicion or a traffic violation. Okay, that's number one. Next. So for DUI charge to stand in court, two things must happen, like I said already: reasonable suspicion of criminal activity, or the officer must observe you committing a traffic violation. And here's the case that I had before, and here's what happened. The person was driving, the suspect, let's call the defendant, was driving, and some person reported that defendant driving, right? So they said that, hey, this person is not driving right. I think she is drunk or he's drunk, right? So here's where we have a little problem, because it's not the officer who watched that person drive, it's another person, right? So we have kind of the officer will have a problem here unless this person who tipped that officer, let's call him or her snitch, and I'm sorry, pardon my language, I think it's more fun. Okay, it's kind of criminal law thing. Okay, so unless this person snitch, right, is being proved as a reliable confidential informant, right? So, and we don't know, let's say this person was not informant before, it's just a regular person driving. So this is not going to work, because the officer must himself or herself watch the defendant, right, driving, so that the officer must have reasonable suspicion in order to pull that person over. Okay, and next, number two, police must have a probable cause to arrest the driver. And here's the trick: events must occur in that order unless we have a checkpoint, and everybody is familiar with checkpoint DUIs, right? Or we have a car accident. Let's say we have a car accident and the person was injured, and they called the 911, and then 911 arrived, and here we go. We don't need a probable cause. We already have a probable cause, which is an accident. Okay, or a checkpoint. A checkpoint doesn't need a probable cause because Supreme Court of the United States upheld that checkpoints are constitutional. Okay, so here's what we have. We have a reasonable suspicion or a traffic violation, which will lead the officer to have a probable cause to arrest the driver, because we know that per Fourth Amendment, we are free from unreasonable search and seizures, unreasonable arrest, unless the police officer has a probable cause or a warrant. Okay, so it's a probable cause or a warrant. Nobody can be arrested without warrant unless the police has a probable cause. Okay, so next, so let's say, I'll give you an example. Let's say in public place, we have a person just who is walking by, right? And we have a police officer who is standing there. And the police officer saying to that person, hey, come over here. Let's say he is Hispanic or he is African American. And so he says, hey, come over here. So that's that's no reasonable suspicion. Why? Because this person didn't do anything at all, like zero. He didn't commit any violations, walking traffic violation. He didn't do anything wrong. And the officer just decided to harass that person because of his racial, ethnicity or national origin. So that's unconstitutional. He cannot do stuff like that, right? So we need to have a reasonable suspicion for the officer to approach that person. Why? Because, without that, we have a violation of the Fourth Amendment. Okay, next slide. All right, here we go. Here we have DUI equal reasonable suspicion or traffic violation plus probable cause to arrest that person. Okay, so we have reasonable suspicion. Reasonable suspicion is objective standard. What objective standard means is that it is reasonable under the circumstances. It's not whether it is reasonable under that officer's circumstances in his head, right? But whether it's reasonable for a reasonable person under the circumstances to suspect that something is going on here, like criminal activity is going on, right? So intuition, like I said here, intuition will not work, right? Intuition will not work. Now, let's go to the next slide. Okay, so reasonable suspicion, what is reasonable suspicion except traffic violation? You're probably a little confused about this kind of legal wording. Okay, it's very simple actually. As far as DUI and driving, we have a DWI, detection and standardized field sobriety testing, which was issued by NHTSA, which is a part of the governmental agency, and this is the which picture you see now on the right. So that manual is used to train officers, right? When they go through this training, they read this manual, they do testing, they will become certified DUI officers. Okay, and that's the training that they do. Okay, so what is the reasonable suspicion? Again, we have cues, right? There are about 30 cues, according to this manual, or 24 to 30 cues by National Highway Traffic Safety Administration for detection of that, whether the person might be driving under influence of alcohol or drugs. Okay. So again, so according to this NHTSA DWI detection standard field sobriety testing manual, we have 3 phases during which a police officer observing the vehicle and decides whether to arrest this individual. Okay, so first, and that's again, it goes to towards the reasonable suspicion. Okay, he or she will observe the officer first. Phase 1, vehicle in motion, right? The first officer observing vehicle in motion. Then phase number 2, the officer makes personal contact with a driver. And then the officer does pre-screening arrest, right? Screening before the arrest. Okay, let's go to next slide. Okay, so first, vehicle in motion. The officer observes the vehicle in operation and determines whether to stop the vehicle and observe the traffic stop. Here's the interesting thing, guys, about this, right? So the officer might not even have a reasonable suspicion that this person is driving under the influence of drugs or alcohol. However, this is where they gather majority of their cues, is when they initiate the traffic stop by putting the blue lights on. they're watching your reaction at this point. When they turn blue lights on, they're watching your reaction, how you're going to react to this. Okay, and this is where they gather majority of the evidence. This is juicy one, right? This is when they're actually watching you now. Okay, if they didn't have enough evidence before, now they're going to get it, more and more evidence, so they're watching you first. And a lot of times, guys, it's very important when they write their reports. And like I said, I've been practicing DUI law for over 9 years, and I saw plenty of reports, and I know how they structure their reports. And they always put in their reports how the person reacted when they initiated a traffic stop. It's in every police officer report. It's very interesting because I think they're getting trained to gather a lot of evidence from that exact moment. Okay, so like I said, there's 24 cues for reasonable suspicious, which could indicate, because it's not beyond a reasonable doubt that the person is driving under DUI, that the person is DUI, right? Okay, so now, like I said, this stopping, this, observation of how the person will react to blue lights will be like, that's when the evidence start piling up, right? Because when person is intoxicated, and I saw it myself when I'm driving now, because I'm obviously went through this training, and I can actually tell when the person is intoxicated, as well as that's so funny, as well as my son. That's interesting. I think it's very funny. Okay, so next, vehicle in motion. Like I said, we have 24 cues according to NHTSA. However, there are about 30. I counted 30. They're saying 24. Okay, so here's what they can be. There are 24. It's a lot of them, guys. You can go to my website, or you can watch this video again. They're basically, they're everything. They're swerving, they're speed, braking problems, they're judgment problems. This is happening when the officer pull you over and you decide, hey, where do I stop? What do I do? So you're in panic mode. And when you're panic mode, when you're impaired, it's very difficult to make a decision because you're very slow, right? Okay. So weaving the lanes, right? You cannot stay in a proper lane. You go under the speed limit. You're very slow. You're trying to be extremely careful because you're a DUI. You can be DUI, right? So that's when they're actually watching you going slow than normal, and they're like, well, already that's actually a reasonable suspicion. So I saw it myself many times on the road. Driving without headlights, improper stop, kind of hitting a brake, anything like this. And you can read, like I said, I'm not going to go over everything. It's like you can see 28 actually, right? Inappropriate behavior, driving in different direction, driving one way street, the opposite direction. So when you're impaired, you're confused, obviously. So that's why I don't get impaired. Okay, so here you can see that 24 cues, they're not clues, they're cues, right? So that's different. Clues are different from cues. Cues, it's signs. That's what it means. It's in professional DUI language, means signs. Okay, let's go next. So phase number 2, personal contact. That's when the officer already gathered all kind of juicy evidence against you, because he was sitting there with his little report card. And a lot of officers, they already have pre-made card. For example, D'Iberville Police Department. Hello, who is watching me? They actually, I must compliment, they're actually very good. They have a specific already pre-made cards, and they just go check, check, check. So it's very difficult to sometimes find someone who's got their stuff together, right? So sometimes they have already pre-made, everything is pre-made. They just have to check for cues also, right? They have pre-made cues, and they have to just check what they observed while they were driving. Okay, phase number 2, personal contact. That's when the officer decides to pull you over and order you to stop out of the vehicle. So here the officer is watching you again. Very important. I saw it in a lot of reports when they order you to step out of the vehicle, right? And this is very red flag. And so usually they have their dash cam, right, on their car. They have their mics on. They're recording everything. That would be a good officer who is ready to go to trial. He will be obviously recording everything. And so everything is being recorded, and they order you to step out of the vehicle, and you step out of the vehicle, and let's say you fall down. When you fall down, that's really bad. Okay, that's almost a probable cause for arrest. Right? So they're watching you getting out of the vehicle. They're watching you. That's important. They are looking at your reaction when they order you to provide your license, registration, insurance. They're watching your reaction, how you're going to react, whether you'll be ready to pull out your driver's license right away, or you will be thinking, where are they? So if they're looking at you and you're like kind of slow, they'll be like, red flag. Okay, another cue. So also they are looking at, they're observing you, right? They are looking at you. That's a cue as to vision, right? What they see. And this is very often, I see this in reports, bloodshot eyes, right? They're looking at your eyes. Well, and we will talk about defense later on, but this is first, I'm going to kind of put out there what they're looking for. Bloodshot eyes, soiled clothing, tumbling fingers, alcohol containers. This is big one, right? Bloodshot eyes, alcohol containers, biggie one. Drug, paraphernalia, bruises, bumps, scratches, unusual action. Okay, they're very often they put this one, blood shot eyes and alcohol containers. That's why I'm telling people, never have an open alcohol container or an open alcohol container in your vehicle. Very bad idea. Bloodshot eyes, well, this can be defended, right? Because if you work long hours, and specifically if you're coming back from work, you're wearing your uniform, and then they write in their report bloodshot eyes. Come on, everybody has bloodshot eyes. I have bloodshot eyes all the time. So that's not really a big one if you've been working all day. Now, cues as to hearing. Okay, so they're also listening to you. They're not just watching you, they're listening to you. Okay, so their cues that they're looking for is slurred speech, admission of drinking, inconsistent responses, unusual statement, abusive language. Well, there's abusive language you shouldn't be using. That's a bad idea. You can catch actually a separate charge for that one. Okay, so now slurred speech, defense to this cue is that you have speech impairment, right? Admission of drinking, guys, this is big one. I mean, don't give your consent or admit to drinking. You basically ruining your case, right? By consenting to search, you are waiving your Fourth Amendment rights, as well as your right to have a lawyer present, right? Which really kicks in after the arrest, but still, you can request an attorney, and we will talk later about that. Admission of drinking, bad idea. What they like to ask you also is, where are you coming? Where are you going from? Where are you going to? Where are you coming from? Okay. So, well, really, you don't need to tell them. I mean, you can be very polite, but you can ask them, well, I prefer to speak with my lawyer. Okay, I would love to tell you everything I know, but I would love my lawyer to be present. Is this okay? Can I call my lawyer? Okay. All right. Now, inconsistent responses, like I said, what they're doing is before arrest, because you're not formally entitled to an attorney now, they're gathering evidence against you. More evidence is better for them. Okay, so again, responses, they're looking for responses. They want you to talk, right? Now, alcohol, beverage, marijuana covers up odors. This is covers up odors. They are like another one. It's like, let's say if you have a lot of perfume on you, like why you have a perfume on you, right? Why you have a lot of perfume at 12 o'clock at night, which is reasonable for a lady, not reasonable for me. And well, depends. But again, next slide. Okay, so phase 3, pre-arrest screening. That's when we have our standardized field sobriety tests. Okay, you guys heard about them. They're very popular. They are, all over the place. So the one that right now is are accepted, right? Those are the one that I listed here, and we'll go over the one which are not accepted any longer. So first one is horizontal gaze nystagmus test. Okay, it's involuntary jerking of the eye. So what happens is you heard about that. They ask you to look at your at the finger or at the pen. They usually hold the pen, and they're slowly going to the left. The first step is going to the left, and they ask you to follow the pen, right, or a pencil. And then you look at them straight and you follow. So while you're doing that, if you're intoxicated, you will experience jerking of an eye, because eye doesn't stay in one place when you're intoxicated. So that's the first sign. And this is the most reliable standardized field sobriety test. It's jerking of an eye. horizontal gaze nystagmus test, involuntary jerking of an eye. That's the most reliable test, and they love to use this one. Every report, they put this one first to go. Okay, defense to this cue is I have an eye problem. I have a prescription. So the officer on a duty to ask you whether you have any eyes problem, whether you have a prescription where you wear glasses. And I saw it in a lot of reports. Officers are very careful about that. And they always like, well, I asked the defendant whether he is wearing glasses and he said no. So I see this in a lot of reports. Okay, walk and turn. Now, walk and turn, one leg stand. The walk and turn test. You saw this one too, like in movies. Jim Carrey movie. I think there is I forgot the name for it, but yes, he did a walk and turn. Okay, so walk and turn is the divided attention test. One leg stand, the same divided attention test. So what's happening here is person who is intoxicated, they cannot multitask. Okay, because intoxication, disabling that kind of a function, so they cannot really function. So walk and turn, divided attention test, and the argument here is that I have impairment, right? I have medical condition with my legs which do not allow me to walk straight or to stand on one leg for a while. Also the defense is that I'm older person, right? You're over 65. Also other medical condition, and it can be slippery road, it can be raining, it can be dark. So these two, they are not very reliable. They're also acceptable, but they are not as reliable as horizontal gaze nystagmus test. Okay, now the most reliable evidence is which be a properly admitted BAC, right? BCA. So now let's talk about the portable breath test. Portable breath test, I saw it in a lot of reports. PBT is not admissible as evidence in trial. However, the officer used this very often to support their cases. For example, they like to go pair this manual. I'm going to show to you, right? This manual. This is the old version. If you want to go get a new one, I posted the name of a site, so you can go get a new manual. But yeah, so PBT, like I said, portable breath test is not admissible as evidence. Okay, now what we're going to do is going to be more interesting part for my Mississippian friends. So we're going to go through Mississippi DUI laws. Okay, so let's look at what we have here in Mississippi. Okay, so here's what I get asked a lot of times by people, right? My friends, family members, but anybody. So if I was pulled over for DUI, can I refuse to be tested, right? And the answer is no, you cannot. Okay, let's look at implied consent law in Mississippi. And here's what you have. You have section 63-11-5, 1A states that a person who operates a motor vehicle upon the public highways, public roads, and street shall be deemed to have given consent to a chemical test of his breath, blood, or urine for the purpose of determining his BAC, which stands for blood alcohol concentration. Okay, so when you get your driver's license, you jump in the car, guess what? You are consenting to be tested at this point. So what happens if you refused? Okay, so let's look at that. Refusal consequences. Evidence of refusal are admitted at trial against you. Automatic suspension of driver's license for longer period of time. And you will not be allowed to do non-adjudication or extension of your driving privilege before your trial. Usually in Mississippi, they do automatic extension, or your lawyer can file a motion to keep your driving privileges. You get the order from court, and that's what you use during your driving period before you get a trial. You get into trial, right? So you still can drive, and if you get first DUI non-adjudicated, then you can drive with interlock device, and you can manage to keep your license functioning, right? So okay, next slide. All right, Mississippi Code 63, Section 63, 1130. Let's go over the Mississippi DUI law and see what's going on. It is unlawful for a person to drive or otherwise operate. Most common test. Okay, we'll talk about this in a second. A vehicle within the state if the person is A, is under the influence of intoxicating liquor. B, is under the influence of any other substance such as drugs, illegal drugs, is under influence of drugs, or has BAC level, blood alcohol concentration level, 0.08 or more, or 0.04 for commercial DL. Okay, we have Mississippi zero tolerance for minors. All right, so here's the thing. We're not going to talk about DA commercial license since it's kind of like, I'll make another video about that. It's a lot. It's the whole section about this. But however, I can tell you that holders of commercial driver's license, they are not eligible for non-adjudication, and they can get a longer suspension of their license. So basically, there are much stricter penalty than regular license, than regular DUI. Okay, next slide. DUI penalties in Mississippi. So now we go through penalties. So what penalty you can get for DUI in Mississippi? Now, first offense, if you are convicted, you found guilty of misdemeanor, what fines you're looking at? You're looking at $250 to $1,000 fine and court cost in Mississippi, or 48 hours of jail, or both. So what happens in Mississippi is if you get arrested for DUI, you get booked in county jail, usually, right? If you are been arrested in the county limit or city limit, you go to county jail, you post a bond, you bond out, you get your trial date, right? So sometimes you get they will let you go on your own recognizance. Okay, so that's how it works. So then you get your court date, you get your arraignment first. If you've hired an attorney can waive your arraignment, and then you can go to court with an attorney will get you a different date. Now, also you will have to complete MACE-UP. Okay, it's alcohol, basically rehab course, right? So how to not drink and drive. And then there is a victim panel, one class that you will have to do. I believe it's 4 MACE-UP classes and 1 victim panel. Non-adjudication under subsection 14, and you can get non-adjudication if you did not refuse and it's your first offense. And we're going to go through non-adjudication in a second. Like I said, DL, commercial DL, is ineligible for non-adjudication, and we have a specific different section about interlock restricted license. Okay, so number 2, second offense, right? Let's see what you can get if you're convicted of second offense DUI. The offense must be committed within 5 years period, right? So this is 5 years. This is an absolutely new thing to Mississippi. Well, it's not very new, but it's new as far as for DUI. If you get convicted, that's very, very strict consequences. Okay, so second offense must be committed after first one within 5 years, right? If you get another DUI after 5 years, you will be charged with first DUI again, right? But you will not be eligible for non-adjudication. It's also misdemeanor second offense. I will look at the fines: $600 to $1,500. Now we have 5 days in jail, 5 to 6 months in jail. And guys, watch that. The minimum penalty shall not be reduced by prosecutor or a court. Okay, so this is very, very, very strict, right? So they cannot reduce it. Third offense, the offense must be committed within 5 years. Again, we have 5 years here, period, right? So all 3 DUIs must be within 5 years, or there will be no third DUI charge. All right, or conviction. Now, third DUI in Mississippi is felony. We're looking at, and felony, we know it's a circuit court, not city or a county. It's a circuit court, but first it will go through county court, right? Because the judge will have to find a probable cause. Now we have a third DUI is the felony. The fine or court cost, we have $2,000 to $5,000 fine. We have 1 year - 5 years in MDOC custody, which means Mississippi Department of Corrections. Now you can get house arrest. Here is an option, right? A jurisdiction circuit court. Now, fourth DUI, you will not see it here. Let me try to remove myself. There we go. If you see over here, for DUI, 5 years do not apply. So for DUI, they can go back as far as they want. You got DUI 20 years ago, they will go back 20 years ago, get that DUI in order to convict you, in order to charge you with fourth felony DUI. So you got to be careful, right? 3K to 10K fines, 2 to 10 years in MDOC custody. So this is not a joke now, right? So you actually facing from 2 to 10 years in MDOC custody. Yeah, definitely, guys. I mean, if you don't have money to hire a lawyer in circuit court, if it's felony, they're charging you with felony. They have public defenders. You have a right under the Fifth Amendment of the United States Constitution to a lawyer. If it's a city court, you can ask to get appointed a public defender. You can file the affidavit of indigence with a judge, and you can ask for a lawyer. DUI is very serious offense. Okay, let's talk about non-adjudication. We have section 63-11-30. Subpart 14. So what does non-adjudication in Mississippi means for DUI? It means that the court would withhold adjudication of guilt and sentencing either at the conclusion of trial or upon guilty plea, right? A lot of prosecutors, what they love to do over here is they like to act like a judges, and they would like to say, hey, if you go to trial now, if you decide to make my life miserable, basically, they're going to say, hey, I'm not gonna, advise the judge for non-adjudication. I'm not going to go on adjudication. But here's the deal. Here's my answer to them is, well, first of all, it's not up to you whether you can get where my client can get non-adjudication. It's up to a court to decide. And then he would say, like, well, I'm not going to go with this recommendation, and that's okay, right? If your client wants to go to trial, if my client wants to go to trial, if I see that it is reasonable under circumstances, I'll take it to trial. I don't understand, why the prosecutor can say something like, well, I'm not going to suggest non-adjudication. Well, that's fine. We're not asking for a recommendation. We're going to trial. And I saw in many instances when person went to trial, still got non-adjudication. So there is nothing in the code or in the law, right? In this book, for example, right, that I just purchased, a very good book. There's nothing. It's Mississippi Criminal and Traffic Law Manual. It's 2022-2023 edition by Blue 360 Media. So there is nothing to prevent you from getting non-adjudication, even if you decide to go to trial. Now, again, excuse me. One-time eligibility. Now, if you got DUI charge, you're applying for non-adjudication, you can get it one time in lifetime, right? There is no such a rules. You can get it every time. Now, not holder of commercial driver's license. We already spoke about that. Okay, so different types of DUI tests. Now, we're talking about the most reliable DUI test, right? It's a blood, urine, saliva, and of course, breath. Breath is the most common. Sometimes they can draw your blood if you refuse. If there was an accident, then they will draw the blood. And breathalyzer, usually it's Intoxalyzer 800. That's what they use around here, and I believe in most majority of jurisdictions. And let's talk about DUI checkpoints. DUI checkpoints with roadblocks. Sometimes a lot of people wondering, well, this is unconstitutional to have a DUI, checkpoint. How that's possible? Well, guys, Supreme Court in Michigan Department of State Police versus SITS, if I'm saying it right, 496, it's citation US 444. And I believe it's, let's see, it's 1990 case. Okay, it says that that's perfectly fine. DUI checkpoints, they are constitutional because we have a great duty to protect a public. So public interest here overcomes interest of the person to keep his privacy or her privacy to himself, right? Okay, so here, all drivers, what happens at DUI checkpoints? All drivers briefly interviewed by police. Detained drivers are subject to field sobriety tests and BIC tests. Golden opportunity for the police to arrest for DUI, of course. They're saving a lot of money against, like I said, liberty interest of general public. So they violate our Fourth Amendment. That's what happened. Okay, in the 1990s, the Supreme Court of the United States upheld the constitutionality of DUI checkpoints. So they're perfectly fine. Okay, defenses. Let's get to the Good one. Good stuff, right? Defenses. So you're probably thinking, I have a DUI and I'm going to plead guilty. Why? Because there is no way I can win this case. Well, it's a BS. I can tell you guys it's a BS because you have, first of all, you need to see your discovery. What is discovery? Very strict rule is that whatever evidence the prosecutor has in his case, right, which he has a duty to prove beyond a reasonable doubt, and we're going to talk about that in a minute. I'm going to show you a chart of reasonable doubt chart. It's my favorite chart, which is admissible into evidence in the in Mississippi. There is a case law on that, and I can tell you that it's actually, a lot of times officers make mistakes. A lot of times they don't do tests, specifically if it's not DUI trained officer. They don't know how to perform the test. They think they do, right? But then when you start asking them, so how did you do your horizontal nystagmus test, and they kind of like even don't know how to properly look at the left, look at the right. They don't know that it needs to go to the left first. So here we are. So get your discovery, contact an experienced attorney. If there are any tapes, recording, dash cam, anything, you need to see those. You have a right to see the evidence against you in criminal case. So here we go. Every DUI suspect is innocent until proven guilty beyond a reasonable doubt. And we're going to talk in a minute what is a reasonable doubt. Now, you have to hire, of course, experienced DUI trained lawyer. Nobody hire public defender. Admissibility of evidence, and that's a juicy one. You can file a motion to exclude certain evidence because they're inadmissible. For example, we have like PBT, portable testing, right? Portable testing. PBT is an admissible evidence in court under the law. Like I said, we have a lot of defenses. If you have any impairments such as legs, eyes, weight, age, health, the weather condition was bad, it was slippery, it was rainy, so anything like that, okay, so those evidence can be excluded for the purpose that they're unreliable. Also, your attorney can file a motion to suppress the evidence because the stop was unreasonable. Let's say the officer harassed you based on the profiled you, right? Based on the national, original, or color of your skin. Also a big one. Okay. Also, improper instruction, a test, improper performance of test, insufficient if the device, let's say Intaxilizer 800, was insufficiently calibrated, right? There was a problem with device. It wasn't calibrated a certain amount of times when it has to be calibrated and, checked. So also the officer did not keep his tests, in a proper store, did not store his testing properly, right? If the officer had to draw the blood or some kind of other evidence, properly failed to store the test kit. Gap in chain of evidence, missing evidence, failure to properly calibrate, like I said, the test equipment. It's a big one too. Also, guys, I saw in some report, I think the officer was like old school, completely old school. He actually did a Romberg test. And Romberg test is inadmissible and has been for a while now. They're insufficient, right? They're inadmissible evidence. And those are the vertical gaze nystagmus test, a Romberg test, finger to nose test, and alphabet test and counting test. Those are inadmissible. And actually saw the Romberg test in one DUI report. And I was like, well, this guy's old school. Okay, so let's see what else here. And I'm going to see what we have. Okay, like again, guys, police reports in Mississippi are inadmissible. You must have the officer to testify on a stand, right? Because essentially police officer is testifying as an expert. Okay, expert in the field, a DUI trained officer. That's who the officer is, and he must prove his case beyond a reasonable doubt. It's his job, and you guys paying taxes for that, so he better do his job right? It's not that complicated. Okay, well, if they don't do their job right, then we do. Okay, so again, every suspect is innocent until, in any criminal case, you are innocent until the state proved their case beyond a reasonable doubt, and it's their job to do so. Okay, now police report is inadmissible hearsay unless statement made by the statement, you made some detrimental statement against you. So if you made some detrimental statement against you, that is admissible in a police report, right? So it's a statement against the interest, an exception to a hearsay rule in Mississippi. Also, charts, diagrams from the police report, for example, in an accident when the person is trying to admit that into evidence, the police report is inadmissible. However, in Mississippi, attorneys before used to file police reports with their complaints in court, and then they stopped that because it's a hearsay. And what is admissible, however, it's a diagram, right? In the police report, there is on the back the crash report. There is a diagram that was drafted by a police officer. Police officer here is an expert, so that's going to be admissible. Next, okay, here's my favorite chart. Let's look at that. Burden of proof beyond a reasonable doubt. That's a chart. That is a chart that is used very, very often by criminal defense lawyers. Why? Because if you look at this chart, police must prove your guilt, that you are DUI, beyond a reasonable doubt. And that's for the jury or a judge to decide. Depends where you're getting tried. If you're trying for felony here in Mississippi, it's a circuit court. If it's misdemeanor, you are not entitled to jury trial. Okay, burden of proof. And I usually point this out to jury. I can point this out to a judge. I did both before. And you can look at it. Like, for example, let's say, so police must have all the evidence. They must put this, what we're going to do is we're going to put them all on a scale and see if they're going to reach this high point, which is guilty beyond a reasonable doubt. Now, the argument is to the jury, let's say to the judge, and during the closing statement is that no, their evidence did not reach even this or this point, right? Therefore, they cannot convict beyond a reasonable doubt. Now, let's say if we have a PBT, portable breathalyzer, like test, and if we have let's say if we have sobriety test, but we don't have the BAC test, right? Blood alcohol concentration test. Let's say we have a intoxilizer machine which malfunction. So now there is no way it's up here, right? It can be a possible is, judge, there is no way that the state can convict this person beyond a reasonable doubt because all the evidence, we're putting them on a scale and they must reach up here in order for this person to be convicted beyond a reasonable doubt for this crime. And the argument is the state only raised their level to a probably guilty. Probably guilty is not guilty. It's not beyond a reasonable doubt, therefore no conviction. So that's what the argument is, right? And if you hire experienced defense attorney, DUI defense attorney, that's exactly what the DUI defense attorney will argue. The judge, it's not the state failed to prove this case beyond a reasonable doubt. If we look at each evidence that we have in this case, there's no way it can go on up here, right, beyond a reasonable doubt. Okay, let's see next slide. Okay, and finally, references. So let's see what I used here. Like I said, if you guys interested, look at the participant manual, look at the stuff that police officers are getting in order to convict you for DUI. Look at the book itself, what they're getting trained on, what they have to read and test. And I believe they have to gain 80% in order to pass, in order to become a DUI certified officer. So you can check this out and get more information on their website, www.nhtsaccaps.gov. Look at the participant manual. Also, what I used to create this outline is Arizona, which I really, really like. I think it's a really good book by Scott Stewart and Colin Bell, attorneys in Arizona. I think they did a great job with their DUI book that I purchased on Amazon. Okay, and also we have Mississippi Criminal and Traffic Law Manual by Blue 360. This book was written for cops and studied by lawyers. Okay, so this is new edition. It's very good book. If attorneys watching me, Mississippi attorneys DUIs, I know guys are using that one, but this is like a fresh edition. Okay, so that's it. Again, about me, my name is Natalia Porsche Okunievsky, former name. I graduated from I have a Juris Doctor degree from Loyola University, New Orleans. Guys who went to Loyola, hello. I'm licensed in Mississippi and New York. I practice DUI law, have been practicing DUI law for over 9 years. I'm DUI trained, experienced criminal defense attorney. I took a bunch of DUI classes. I'm a member of Criminal Defense Association. Um, of attorneys. And if you are interested in talking to me about your DUI case, if you have a DUI charge pending, you can do so. You can give us a call. It's 228-229-7500. And or you can visit our website, www.okunievskylawfirm.com. And guys, you can also go to this website to download this beautiful outline that I have created for you to read if you are interested. And I know a lot of people interested if you have this sort of case pending that you would like to know what's going to happen. And thank you so much for watching. I see that I'm like over 50 minutes, so I will have to leave now. And thank you so much for watching. I would like to continue with my outlines. If you watch me guys on YouTube, please subscribe, put thumbs up so that I can keep going with my videos, so that I know someone is watching, someone is interested in watching this. Thank you for watching and have a great weekend. Goodbye.